My presentation would consider abortion, the issue of abortion in the within the European context. The European context, I mean the law of the European Union, as well as the certain legislative instruments and the case law of the Council of Europe, which were adopted within this milieu. And I hope this presentation would fit with other presentation of the panels, because the next speaker, Justice Borrego, would speak about the case law of the European Court on Human Rights on abortion. So I would skip the issue and focus maybe a bit on some cases concerning in vitro fertilization. And I hope also my focus on legislative instruments would be supplemented by the presentation of Dr. Kugler, who would focus on some practical aspects concerning the promotion of the protection of life in the prenatal phase and combating abortion. So my preliminary remarks concern the explanation of the topic. The European context, as I said, it is the law on the European Union, as well as the Council of Europe. And to be or not to be a parent, I was focusing on certain opposite trends which are present in the contemporary culture of people, of couples who want to become a parent, who expecting certain difficulties start using IVF methods, which were designed as methods, in vitro methods were designed as the methods of last resort, but nowadays there is a trend to use them as a first method while having some infertility problems. So there is also a question of the proper use of that methods, if any. And I would like to focus on the relevant means concerning the termination of the pregnancy. And in fact, as Professor Hilgruber noted yesterday, abortion doesn't mean that one is not a parent or there is an exclusion of the possibility to become a parent because he or she is already a parent. There is an embryo, there is a fetus, there is a child, so abortion means just stopping being a parent. I would like to focus first on some general data concerning abortion, just to have a more general viewpoint concerning the European regulations. So as the UN document, World Abortion Policies 2011 states, there are 7 grounds on which abortion is permitted, and each country in the world has a certain combination of those factors. Of course, it doesn't mean that each country has to use those grounds. There are 7 countries that ban abortion completely, so there is a possibility not to have the access of any of those grounds. And there is a certain trend as far as the evolution of abortion law is concerned, that the scope of abortion legislation is progressing, as well as its actual execution, and there is a discrepancy, or there is a difference between abortion law in the developing countries, which has less restrictive abortion law in comparison to the developed countries. The UN document also states certain procedural rules which limit access to the abortion, and I think there should be, one should put importance into those procedural rules because, in my opinion, the use of those procedures may limit the execution of abortion. They are designed to either to limit the use of abortion because of the development of a child, the development of the fetus, embryo, fetus, and an unborn child, or to have certain instruments which are designed to rethink the decision. In practice, they limit the execution of abortion. As far as the legislation of the EU member states on abortion is concerned, the legislation vary from state to state. One may state one general remark is in comparison, for instance, to the American practice, the American legislation on abortion, that it is not the policy of at any time, at any reason, allowed abortion, but every European country has certain limitation on the access of abortion. So one may state that the access to abortion is allowed only after fulfilling certain conditions, and one may state that the most important of them, or the most common, is the gestational requirement. So the abortion is legal only within a specified period when the child is developing. It may be a twist in language. It's either abortion which is legal, or the protection of life, of unborn life, is executed in every member state, and there is only the exception of abortion while certain specified conditions are fulfilled. There is an example in Europe of Malta, which bans abortion completely, and this is the example of one of the 7 countries which does not allow to terminate the pregnancy in a medical way. As far as the European Union law is concerned on abortion, it looks horrible. The regulations on the page you are now may read, but don't worry. It doesn't say anything about abortion. It says only about the provision of healthcare and the division of competences as far as healthcare, as medical services are concerned. And the most important remark here is that it is for the member states to organize, to deliver, to make a definition of health services, of medical services, in accordance with the principle of subsidiarity. So any European body, any European law provision, legal provision may only help to organize health services within the member states, and there are certain instruments and certain blockades invented within the European law which help to guarantee the exclusive competence of the member states. It is for the member states to organize it, and the member states are very careful not to allow any European law changing this because it is a very delicate matter concerning also the management of resources, linked to the designment of the social policy. So this is a very delicate problem, and it has never been allowed to be decided on the European level. The other issue is, or one may say that the example of such an attitude is the very famous case which was decided by the Court of Justice of the European Union on the case of the Society for the Protection of Unborn Child, SPAC, from Ireland, against Stephen Grogan, who was the president of the Students' Union. And the case concerned the national legislation, Irish legislation, prohibiting abortion and the possibility to to disseminate information on the possibility of having abortion in other member states. The most important, in my opinion, issue which was decided by the court is that the medical termination pregnancy was considered by the court as a service within the meaning of the treaty. So abortion is a medical service and is subject to rules in the, stemming from the treaty on the European Union. But the court stated that the legislation on abortion, legislation on any medical service must be performed in accordance with the law of the state in which it is carried out. So, in order for the abortion to be recognized as legal, as being subject to European provision, two requirements must be fulfilled. First, it must be recognized as legal within the member state. And secondly, it must be executed within the territory of the very member state. So if any of that conditions are not met, then the medical service may not be recognized as legitimate, as legal within the European Union law. And therefore, it is for the member state to decide whether abortion is legitimate, is a legal instrument within the member state or not. And the court directly, expressly stated that it is not for the court to substitute its element for that of the legislator of those in those member states where the activities in questions, where abortion are practiced legally. So one may state that there is a possibility for the member state to ban abortion, and the European Union law is not relevant instrument at the moment. And one of the instruments which safeguards such a possibility, such an free will, one may say, of the member state, is the instrument of imperative requirements of public interest. It is a legislative technique, it is a special instrument which was designed in order to protect special, particular values of the member states of the EU. It means that each member state may adopt legislation which is contrary, contrary to fundamental freedoms of the European law, which were adapted for the protection of that very particular reason. And I have listed any other requirements, procedural requirements, that rules in question, norms in questions must be non-discriminatory, must obey proportionality test. There are other instances, not only abortion, but also other cases which were decided in favor of special instruments which were designed by the member states, gambling, prostitution, or distribution of certain military or aggressive-prone materials. And I would like briefly to state something, some comments on the policy and case law of the Council of Europe. The most relevant issue within the Council of Europe milieu is the resolution from 2008 concerning access to safe and legal abortion in Europe. The resolution states that it is also ambiguous, and one may state that there are certain provisions that may be regarded as prone to the ban of abortion or protecting human life in the prenatal phase. Abortion must, as far as possible, be avoided. Abortion should not be banned within reasonable gestational limits. So after those reasonable limits are gone, then abortion should be banned. But abortion is recognized as a right of a woman to decide. So there are certain requirements, specific requirements for the member states. I think within them, the most important is 7.8 concerning the promotion of more pro-family attitude in order to avoid situation where abortion is being done due to certain social or economic conditions or financial pressures. And I'm skipping the European Court on Human Rights case law on abortion, as you are going to hear about this from the very honorable speaker, which was part of that adjudication process in a moment. Only a few words on recent case law on in vitro fertilization, because it may have some relevance as far as abortion is concerned. And the recent, but not final at the moment, decision in Costa and Pavan versus Italy, the court stated that the question of access to PID, pre-implementation diagnosis, is raised certain delicate issues of moral and ethical nature, and the legislative choices are to be made by the parliament. In another judgment from 2011 against Austria, the court admitted that that there is a wide margin of appreciation in principle extended to the member states, extended to the domestic government. So concluding, I would like to state that it is for the member state to decide to adopt measures which protect human life in prenatal phase. It is their sole responsibility through legislative choices of the member states, of society who elect certain representatives. They have a wide margin of discretion. They may ban completely abortion, as is the example of Malta. It is possible to use certain legal argumentation from in vitro fertilization instruments or case law, or the adopted in 1997 Convention on Human Rights and Biomedicine, which recognizes certain rights of the fetus and embryo. So one may state that if there is a right of fetus and embryo as far as in vitro fertilization is concerned, this may be also extended to fetus which is present in vivo, and to use it as one of the instruments to limit the access of abortion. So my conclusion is that it is for the representatives of the member states, for the society, and this conclusion is specifically important now here at this place in Warsaw in Poland, and as in September or beginning of the next legislative session of the Polish Parliament, there are two projects, legislative proposals that will be discussed by the MPs. One of the proposals aims at completely making the abortion a completely legal instrument. So it ruins all the consensus which was adopted in 1993. And the other proposal goes in another direction, and it aims at broadening the scope of protection of unborn life within the sphere of health impairments. So the proposal is to ban abortion when the fetus is with certain health impairments, and to ban abortion as far as this ground for abortion is concerned. Thank you very much for your attention. I would very much wait for any questions and comments on my presentation. Thank you.